Good morning. What I'm going to do, I'm going to just share with you our experience in Kenya in litigating HIV criminalization. And I think I've done this in the last 2 or 3 years. So this time around, I really want to go into the behind the scenes. I want to give you experiences as advocates who probably would be interested to engage in this kind of work, as journalists who will be reporting on these kinds of cases, as researchers, as who else did we have here? The doctors, the medical perspectives and all that. So I'm really not going into the details of the case. I think you can all read the case. We are all good at this. I probably have already read the summaries. So I'll just go into other details. So just to begin, I'm just going to probably give a few tips in terms of litigating criminalization of HIV transmission. So first, and I'll be doing this as I just move along with the case, our case in Kenya. Just quick tips in terms of timing of the litigation. I mean, most of the times as advocates, you'd sit and wonder, what is the right time to file my case? And I think for us, from experience, when we filed this petition, it was the right time because it happened at a point where Section 24 of the HIV and AIDS Prevention and Control Act came into effect. A notice was given, and unfortunately, this notice was given on 1st of December, which happens to be World AIDS Day. So for us who work around the HIV field, this was a very, I mean, it was as if, we are standing there, we are celebrating World AIDS Day and saying this is the progress we've made in terms of human rights. Yet on that same day, then a notice comes to effect Section 24 of this Act. And just to give a quick background, this is a section that had been under contention within the stakeholders that work around health and human rights because of the issues of the vagueness of the section and the clarity in terms of the legality of that section. So despite having all these conversations, this section comes into effect on that very day. And remember, when you look into the Act, when you read into the Act, the purpose of this Act is actually to eliminate stigma and discrimination. And then this happens, we've had discussions among stakeholders, what does this section mean for people living with HIV and AIDS in terms of stigma and discrimination? So the timing for us was really right. That was the perfect time to file the case. And just in terms of sorry, this is Section 24. You can just read through. I think it's probably similar to the different jurisdictions that we've had from. And for us, at that point, I would say we didn't have a petitioner. So we decided to act as an organization. We decided to take this up as a public interest matter and just challenge the constitutionality of Section 24. And when you're doing this kind of work, I think as we've discussed for the last 2 days, we have allies, we have guys who are against you. So for us, we knew this was the time. We wanted to do this. Of course, within our networks as well, people told us, hey, this is not the right time. Hey, you have to wait for the perfect case. You have to wait for the perfect client. But then we thought, how long are you going to wait? You're not just going to sit there and wait for someone to be prosecuted, and then you come in and say, hey, let's see how we are going to get you out of jail. So we decided to go with what at that point we thought was right, and we filed our constitutional petition. So initially, very quickly, the initial stage of filing, we were seeking temporary relief so that we can stop the operation of Section 24 pending the hearing of the constitutional petition. And unfortunately, we were not granted that order. Again, when you're doing these kinds of cases, you have to be open-minded. We've heard from cases where you succeed, there are cases where you succeed, there are cases which you lose. So you have to be really open-minded, but I think when you're doing public interest litigation, when you're doing strategic litigation, we always say there's no bad case, you know, because for each case that comes forth, whether you win, whether you lose, you're able to, it's an opportunity to actually bring out the issues, highlight the issues that, that people need to know about. So, injunction not granted, but then what the court noted, the judge who was listening to us actually noted that our petition raised weighty issues, and actually sent the matter to the Chief Justice to appoint a 3-bench, because we had, the way we had framed our issues, I think at that point the criminalization debate was still very hot, you know. People were divided, you know. There were people who said, this is a good thing to do. There were people who said, no, we can't do this. So 3-bench was good for us. And if you looked at the bench that was listening to us, I think from experience and from the cases that they've had following the Section 24 case, they would say they were good judges. They were human rights friendly judges. So again, which takes me back to the issue of making sure you get a good, you know, a good judge. If you're lucky to get a good judge who listens to your case, then probably you already have about 50% of succeeding, and then the rest probably depends on how you frame your petition and the kind of research you're relying on, the kind of witnesses, expert witnesses, and all that. Just moving on very quickly, this was our main arguments, and I think we've had this discussion again for the last 2 days in terms of the issues of the vagueness and overbroad laws. What does it mean when a law is put out there and somebody is supposed to interpret it? There's no clarity in terms of what the common man, as we call, or I think to use Sarai's new term, the common woman in the market would want to, would read and understand what exactly that law means. So again, these are some of the issues we are raising, that the section was vague and overbroad. And secondly, that it didn't adhere to the principles of legality of the law in terms of the clarity. What exactly is the offense, you know? Can you point to the offense that that is being forbidden? And then we also raised the issues of the fear and stigma that this section was going to cause in terms of interfering with efforts that have already been done in getting people to test and disclose their status. Again, Section 24 was going to violate the right to privacy. In the sense that as a person living with HIV, you're supposed to disclose your status to your partner. And then we're asking, what is the obligation of your partner in terms of keeping that information safe and also observing the confidentiality. Then in terms of discrimination, again, we're saying this section fosters discrimination against people living with HIV and AIDS. During the course of the hearing, we managed to get an amicus to join our case, the Center for Reproductive Health, and they brought in the different perspective of how this section actually was going to affect women in terms of issues to do with vertical transmission of HIV. Because then, if you read the section as it were, it would mean that we'd be dealing with the case that Wesley was talking about early in the morning, for a woman who actually knows that they are HIV positive and goes ahead to breastfeed their child. They would still be caught under Section 24, as per how it was drafted. So, again, back to amicus, when you're doing a strategic litigation, you're looking at who are the people that we work with that can join in our case to bring in value. And this could be people probably who've done research, a lot of research work in the area that you're challenging. There could be reports from the UN special rapporteurs. There could be reports from UNAIDS, WHO, just depending on your issue, the issue that you intend to challenge. And apart from the amicus, we actually had an interested party who came in to oppose our application, yeah? So the interested party came and they were actually saying that our application should be thrown out because, if that section is struck out, then, it was back to the issues of morality, it was going to, people are going to become more promiscuous, they'll be infecting each other and all that. But thankfully, as during the course of the hearing, the interested party actually, I think, to use the term that I think we've been using for the last 2 days again, they saw the light. KELIN. And Edwin, I think. So the interested parties saw the light and withdrew their application. So we were just left with the amicus, of course, who are supporting our case. So generally, the prayers we were seeking, declaration to declare, declaration that Section 24 was unconstitutional, and that the offense created under Section 24 was wide, vague, and overbroad. And usually you give also the court a chance to make any other orders that they may deem fit. That way you cover yourself for, in case you didn't mention any other prayers in here, then at least the court is able to use their discretion to make such orders. So just very quickly, within when we were doing the petition, of course, we really did a lot of research. This was back in 2011, by the way. So at that point, still, we didn't have a lot of we didn't have an opportunity to sit in this room and have all these kinds of training and insights about how to go about this kind of litigation. So I would say this is really, the times have changed. This is a really good opportunity for all of us seated here, all of us advocates, all the journalists, all the researchers, all the people in this room who intend to push this work forward, that we're really getting an opportunity to be exposed. We're getting an opportunity to make networks and links of organizations and people that we can rely on, we can go back to and actually talk to and share our cases and get experience and get technical support. So this is really, I think, a very good opportunity right here. And then in terms of, I think what helped us, even as we were preparing for the cases, was the resources that we managed to get. Again, and I think we talked about this even yesterday, what research is out there, what research has been done, comparative law, the reports and all that. And more importantly, I think for specifically the issue of criminalization, what does what is the medical aspects, What does it mean, for example, to say that this is this person infected the other first? Whose HIV is it anyway? So all these things really matter for the judges. You have to do a really good job in preparing and making sure that all the research is well done. And then again, in terms of framing the issues and the remedies, I think we had this during the morning discussion. What exactly are you seeking from the court? Do you want the whole act to be struck out? Are you seeking for a very specific order for a specific section and very specifically interpretation of the section? So you have to be very clear. And that again takes me back to the issue of forum. What forum are you planning or intending to file your case in? Are you going to file in the High Court? For us, for example, back in Kenya, we have a HIV tribunal. Are you going to use the tribunal as a forum? Are you going to use the Constitutional Court to challenge the constitutionality of the issues? Are you asking for a law review, law reform? you have to be very specific in what you're seeking in terms of the remedies as well. And then just so very quickly, this was, I mean, it was a difficult time to do this kind of work. We had allies, we had people who didn't support the cause that we were doing. And then, of course, we had another more difficult task of getting journalists to understand. Even as we are seated in this room, I think in the morning when we were doing the group feedback, I think in terms of the issues that we didn't come out very clearly, I think still we see how complicated the issues of around criminalization are, such that despite, as we say, claiming to be people who are well educated and we're seated here and we're still learning, you still, you get out of here and you're still wondering which way to go, in terms of criminalization, which direction are we headed? Do we want a complete, do you want to totally do away with criminalization? Do we want to maintain, for example, intentional and willful criminalization? And in which laws do we want to do this? So I think at that point still all these issues were coming into play, and it was not a very easy thing to convince, of course, the judges and especially the media in terms of getting them to report the right thing. Because at this point it was a sensational story such that if the media actually reports the wrong thing and says a law that wants to encourage people to be promiscuous, something like that, very bad reports going out there. And I'm really glad actually that at this point we have journalists seated here with us, because then we're able to have this this discussion. And also in terms of building partnerships, I think yesterday again we heard that there's a new relationship, a love affair brewing between lawyers and journalists. I think this is really a good space to encourage that kind of relationship, because I can say from experience when we were doing this case, actually we didn't really involve journalists as such. I mean, they came to court and all that, but all we had to do actually was give them a summary of what to report, because they were not very clear on exactly what the issues were. And then that brings me to the point of how important it is to engage, especially with the partners and the media and the journalists and different forum in terms of beginning to do the advocacy and campaigns right from the point of filing, right from the point where you're deciding that we are going to file a particular case, because then it becomes very clear in terms of moving together from point A until the day of judgment. So luckily, 4 years later, from 2011, in 2015, we managed to get a date. We did our submissions and got a good judgment. I would call it a really good judgment, because I think, when you file a case, you're usually expecting to win. But more importantly, you're expecting that what you are seeking, what you're asking the court to do, they actually do it. And we actually got a good judgment, because then the court declared Section 24 unconstitutional because of the issues that we've discussed, the vagueness, the overbroad, and it lacked certainty. And secondly, that in just bringing out the issue of the privacy issue, the breach of privacy that this section was going to interfere with. And in terms of probably just a bit of detail in terms of the broadness and vagueness of the section, I think the issue that was really a point of contention was the use of the term sexual contact. Who is a sexual contact? If you Google right now, just Google definition of a sexual contact, it could be someone you're touching, someone you're kissing, someone you're rubbing yourself against. It could be anything. I mean, what? So it becomes very difficult then, I think, as we've had in the last 2 days, to really say what is the offense that the law this section is supposed to guard against. What is it that I'll be committing? What is it that, at what point am I supposed to be disclosing, and telling my partner about my status, for example? So, good judgment. which I think has been shared, and we can all go and read in detail. And then just very quickly as I finish, in terms of just partnerships, of course, again, it was very important to just begin to work with people who are like-minded in getting the messaging through, and also in convincing the people who didn't support our work that actually this is criminalization does not work, because then you're looking at giving it the public health perspective. How far have we come in terms of getting people to test, in terms of getting people to talk about their status openly, in terms of fighting stigma and discrimination? You know, do we want to take ourselves back for the years we've tried, especially in encouraging people to test with bad laws? So I think really, in terms of moving forward, these are some of the issues then that I think again we have to keep looking at and discussing. How do we continue doing reform and advocacy around issues of criminalization? And at this point now, I'm glad that we are also talking about TB in this very forum. Otherwise, we'll be going through the same cycle with TB again when you start having and seeing the cases. For example, what we'll be discussing here of criminalization of TB. So I really, I mean, as we move forward, even in terms of discussing today and tomorrow, how can we really get a comprehensive law reform or advocacy that covers not just HIV, TB, what I would say, all infectious diseases, or I'm not really sure how to frame this, but I think it's an area where we've come a long way in terms of wanting to know which direction we all want to go. And then, of course, just as I've said, involving all stakeholders so that we are not using the punitive approach, but just getting people to understand that there are other ways of dealing with criminalization. And then I think this is the point where, again, we link it to the issue of ensuring that justice is upheld. For us who work in health and human rights, this is where I think we all get into the point of saying, so how do we deal with the person who intentionally and willfully spreads HIV, So this is, I think that has been our experience. It was not, as I've said, it was something that we were doing. Generally, as an organization, we do a lot of, we'd been doing public health litigation, but we knew that this was going to be a difficult area to deal with because it was still very, very controversial. But having done previous cases where we really managed to do especially the framing of the issues very well from the start, then I think it became also easier to convince the judges. So just parting short, I think what we need to just follow through is in terms of the looking at what happens after getting a good judgment, the follow-up, the follow-through, and just making sure that, again, we are not just going through the cycle of, finishing one case, finishing one disease, and moving on to the next one and starting from scratch on the same issues. Thank you very much.